Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about COVID and family law. A new study has shown that over 5 million Canadians have separated from their partners during the pandemic. While some people have suffered from the loneliness and isolation of quarantining alone, 15% of Canadian couples face the exact opposite problem: too much time together and the realization that they're better off apart. But parenting separately during a pandemic leads to its own problems. How do you co-parent young children during COVID? What do co-parents do when they disagree about in-person school, risk thresholds, masking, and vaccination? How do co-parents work through those disagreements, especially when the courts are faced with huge delays because of this pandemic? Here to weigh in on the novel problems faced by separating spouses and co-parents in the COVID era is a panel of family law experts. Sean Knight, Candy McCarthy, and Anthony Martin are all here to join us. Thank you so much for joining me today. Ms. McCarthy, I'd like to start with you. I've seen these reports about COVID causing a rush of separations. Can you tell me if that's something that you're seeing in your practice?
Well, I can say that this time of year, it's uncommon for us to have a lot of telephone calls. Normally, I get a rush, if you want to call it, of clients in January. But right now, it's been completely steady from last January to date. So I can only speak anecdotally, of course, but for sure, I've seen a lot. We are yielding a lot more calls than we normally do this time of year.
Now, Mr. Knight, what are some of the unique complexities of separating during COVID?
Well, some of the things that my firm is seeing is that situations where there's domestic violence or where there's been very serious issues happening within the family that people kind of lived through before. Maybe one spouse was going to work and it was only violent. Some of the time now they're stuck in the house with them. Those types of situations are difficult because how do you separate when you're both ordered to stay at home? Where do people go? How do you rent apartments and on short notice and all of these kinds of issues? So the actual, while the law hasn't changed, the actual complexities around the practical steps to separating has certainly changed. And it is creating some issues in terms of new complex issues for the court to deal with on short notice.
One of the things I want to ask you about, Mr. Martin, is about the courts specifically. You know, a lot of the courts have been closed, or they've been open and then open again and closed again. What are some of the challenges faced by couples who want to separate or who are having disputes in the midst of co-parenting and want a court to resolve it? How challenging has that been when those courts have been at a reduced capacity?
Well, it's certainly improved from where we were at about a year or so ago when court availability was quite scarce. Courts have responded. We're able to conduct hearings through Zoom, over the telephone. So it's been accommodating that way. But I know in some jurisdictions you can't even get a date for a trial. So parties are stuck in limbo. So they're left sort of hanging and tossing in the wind. Until they can come to a final resolution. So I think, and this is a common theme that I hear from judges, is they're begging people to be patient and just, try to get along as best as we can until things return back to normal.
Good advice. Now, Ms. McCarthy, many people have lost their jobs during COVID. How is this impacting spousal or child support payments?
Well, there's a few challenges with that. One, of course, is if you are under an agreement or an order to pay child or spousal support, it is obviously dependent upon your income. And so a substantial change in that income does allow the court to revisit or review that support amount. And so there is an influx of people bringing forth these issues when, like Mr. Martin indicated, there's a backlog at the court. So it does cause a lot of stress in Nova Scotia, and it's reciprocal, I believe, through most of Canada. We have maintenance enforcement programs. It's called the Family Responsibility Office in Ontario. And so they have very little discretion on what they can do.
We're going to jump back into some more questions on this complicated topic after these commercial messages. Welcome back to Canadian Justice, where we're talking about the unique challenges COVID has created for family law. Now, I'd like to turn to some of the issues arising around co-parenting relationships. We've already seen some COVID-related disputes head to the courts. In a case from this March, a judge in Windsor had ruled that a father's vocal disbelief in COVID-19 was a factor in a child custody case. The man was denied interim custody of his children because of his fervent anti-mask beliefs. His custody arrangement was changed from weekends to 3 times a week and only at supervised access centers. Now, Mr. Knight, how are courts looking at cases related to custody and COVID? What should parents know about how courts will look at their compliance with public health regulations when making a custody decision?
Well, I think what we're seeing in Ontario is that the courts are really focusing in on the facts and whether or not the litigants or the mom and dad in many cases, whether or not they are considering the evidence and the information that's being provided by doctors and healthcare practitioners. There's a recent case in, I think it's called Tarkowski, where there were parents arguing over whether or not their children should be vaccinated, and that's going to be a really interesting topic coming up in September. Are schools going to require people to be vaccinated? And if so, if you're a parent that disagrees with it, what is going to be the result? And I think what the court basically said is, they want parents to make decisions that are in the best interests of their children and based on evidence, advice from doctors, advice from other professionals, and not just based on a bias that a parent may have either for vaccines or against vaccines. And if a parent is biased for or against a vaccine and chooses to maintain that position, the court may actually create a situation where the parent without bias will make the decision. And so this is a growing issue that I think that people need to be concerned about, because there's still some concerns around taking vaccines that parents have.
I'm really fascinated by the vaccine debate. Now, Mr. Martin, I know that there's a lot of case law out there already on vaccines, pre-existing childhood vaccines. Now, would the court look at any of that case law differently from the COVID vaccine, would it treat the COVID vaccine any differently, or is it the same as any childhood vaccine, be it polio or measles?
Well, it really remains to be seen, because the case that Sean just referred to, I think, is one of the only few cases that's actually addressed the COVID-19 vaccination specifically. And of course, now with this week that we're seeing children as young as 10 being eligible to be vaccinated sometime in the future, we're going to see more cases. My view is that I think a parent who maybe subscribes to anti-vaccination views will have a tough time convincing a judge that a child shouldn't be vaccinated. I just don't see how it will be treated any differently than any other vaccination, where the court has indicated that, in Ontario at least, vaccines are generally safe, and there's really nothing to be concerned with. So that will be my guess as to where things are going to go.
Ms. McCarthy, your views on this, how parents can come to an agreement when it relates to vaccinating a child against COVID-19. How do you think the courts will look at this?
Well, the courts have long-standing not been the arbiters of science. So their job is not to determine the science of it. Their job is to look at the best interest of the children. That's the test. And so if the government or the public health is saying that who the court will look at as the experts on where we get our information on health or what we are determining is in the best interest of our citizens, then the court will follow that guideline. So as long as the vaccines are something that's being recommended by public health, I believe the court will err on the side of ensuring the parent who is pro-vaccination will have that decision-making power for the children.
Really, really fascinating topic. When we come back from these commercial messages, I want to ask you about testing as well. I know some parents have had disputes about that, and the importance of timeliness when it comes to testing. I think we probably know where the court would lie on that, but how can we get a result quickly? We're going to come back to that question after these commercial messages. Welcome back to Canadian Justice, where we're talking about COVID and family law. Now, Ms. McCarthy, I want to ask you about COVID testing. I know that there are some parents who've butted heads over testing their kids for COVID. The test isn't pleasant, so I understand wanting to spare putting a child through it. But on the other hand, I can also understand wanting to know if a child is positive. And obviously, the courts are going to side with the best interest of the child, which is probably going to be getting a test. But in that type of dispute, there's really a time sensitivity issue. There isn't time to go to court to resolve the dispute. How do you suggest parents deal with this kind of question?
Well, with all of the issues surrounding something so emotional like a pandemic and trying to parent and co-parent in a pandemic, we would always encourage parents to find a way to work it out. Deal collaboratively, see if you can't come up with a plan together with the assistance of a lawyer or the assistance of a mediator. Failing that, we're often guided by parents who are already separated who have an order. So if a parent has final decision-making authority, I wouldn't question that on the issue of testing. So I think look at your order first or your agreement, see who has a final decision-making authority. If they do, that's the default. That parent is going to make that choice and it should be followed. And failing that, if you cannot work it out, I would tend to think that if my client has the children in their care during their time, that would not be something so intrusive to stop them from getting a test.
So, Mr. Martin, I want to turn back to what we discussed in, the first segment on this notion of custody. I think everyone's doing our best here to comply with public health orders, but some parents have different standards. What happens if mom is upset that she thinks the kids, when they're at dad's house, might be playing with the neighbor's kids or going into the neighbor's house? How would a dispute like that get resolved? What rights does mom have to say how stringently dad needs to comply with public health orders and vice versa?
Well, there's a general expectation from the court that parties will be compliant with COVID-19 protocols, whatever that might be. So my experience has been that there's generally two categories of parents who are, that call me or want to litigate over COVID-related matters. There are those who have genuine concerns that maybe they don't understand what the rules are because they are a patchwork and they're changing all the time, so it's hard to keep up. Then there are those that might be a little bit more sinister and they see COVID as an opportunity to restrict parenting time. So they'll say, well, it's COVID, you can't see your son or daughter. The presumption is that if there's a in place before, then that's what you're going to follow. And only in the most exceptional of circumstances will the court restrict a parent's time with a child related to COVID. And I think earlier you mentioned a case in Windsor where a father was a flagrant anti-masker. That would be a scenario where you would see that, but it's a tough road to hoe for you to restrict parenting time based on COVID.
Now, Mr. Knight, I want to turn to that story from Windsor and this sort of flagrant behavior by this one parent who ended up having his custody order changed. How extreme would the conduct of a parent need to be for it to result in a change to the custody order? And by conduct, I mean compliance or non-compliance with public health orders.
I think it would have to be fairly extreme as it is in that case. If you're refusing to allow your children to wear masks or encourage your children to wear masks when they're attending public places. Those types of things, or just complying with the law. Those types of things would draw the court's attention. But one of the things that we don't get is, like, I've had many cases since COVID-19 started where parents are very reasonable. You know, they might take their kids to a store to eat or something like that, and the other parent decides to stop access. Or they might a neighbor came over and the other parent heard about it, so they stop access. Those types of things draw very negative attention from the court, and that is pretty much what's happening more so. And we're seeing that the court is very much in favor of ensuring that current access agreements continue to be followed unless there's some reason, some extraordinary reason to stop it from happening and extraordinary risk to the children.
Yeah, and as I said, I think we're all doing our best to comply with the orders. People should obey the orders, listen to public health orders, but they're changing all the time. It's a little bit hard for some parents to keep up, I'm sure. We're going to dig further into these questions after these commercial messages. Welcome back to Canadian Justice, where we're talking about co-parenting during COVID. Now, Mr. Martin, I want to ask you a question. Co-parents always need to get permission to travel with their kids outside of the country. But now during COVID, there may be some concerns about not just traveling within Canada, but within the province. Some parents from low transmission communities may not want their kids going into areas that are hotspots. Do parents have any obligations to one another in that respect?
Well, I think the best case scenario for co-parents is to have the conversation and hopefully come to an agreement. But, failing that, again, the parent who is seeking to restrict parenting time, the onus is on them to provide persuasive evidence in support of that claim. I guess with respect to traveling to hotspot areas, it depends on what the COVID protocol is at that time. Courts want to see parties complying with the COVID protocol. Now, practically speaking, if you have a parent who takes a child to outside of the GTA or wherever, what do you do after they've already come and gone? Like that ship has sort of sailed. So I think people just need to they need to pick their battles and just be clear with communication with each other.
Good advice. Ms. McCarthy, you've talked about separation agreements and co-parenting agreements that people already have in place. How do you think the pandemic is going to change these agreements in the future? I doubt anyone put any pandemic planning into their separation agreements in the past. Is that something that we're going to see in the future?
Oh, that's a good question. I kind of hope not. but I think that it at the very least, it makes parents aware that when they're making agreements, not necessarily to be putting their mind to things like a global pandemic, but put your mind to things like in circumstances that are not anticipated, how do we work out problems? How do we approach a problem that isn't covered in our agreement? So I always recommend that you include clauses there about if you do reach if there is a medical issue that you don't agree on or can't agree on, what process are you going to use to come to that kind of a resolution? So this pandemic hopefully is not going to create us having to include a bunch of clauses about pandemics in our future support orders or agreements, but hopefully we'll give parents some insight into knowing that not everything is predictable and we should have agreements that protect parents on how do we make decisions in the future.
Mr. Knight, I have a question about vaccines again, just turning back to that issue. Parents make these decisions for their children who are minor, but what about the other household, the other people in that other household? What right does one parent have to the information about the vaccination status of their ex-spouse?
I don't think that has been litigated yet, in fact, and I don't think it's an issue that has been raised. But I guess from just a legal perspective, I don't think that the the vaccination of the ex-spouse would necessarily be as relevant. I think that if a child is vaccinated, then it certainly is not relevant because the risk would be relatively low. I'm not sure how the parents' vaccination would be relevant. And I'd just like to say in general, I think the call is reasonableness throughout decision making between parents. If we're reasonable, if we're all willing to give a little bit, given the situation, I think it makes life a lot easier, and it reduces the wear and tear on the court system, which is really right now being stretched to its absolute limits.
Really good advice for family law and for life, Mr. Knight. Thank you all so much for joining me. It's been a really informative conversation. We've heard today about the challenges of separating, divorcing, and co-parenting during a pandemic. While some of the challenges for parents remain the same, COVID has created a unique and unforeseen challenge. And the fight over vaccination, always a hot topic, is more pertinent today than ever. How do courts resolve these disputes? When keeping the best interests of the child is at the core of decision making, how do courts make rulings when co-parents have different risk thresholds? And when the science of COVID keeps changing and evolving? When is the time for parents to dig in their heels? And when is it the time to make concessions? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.